Council Dimino, welcome to Constituting America's Constitutional Chats. We'd like to invite you to share some opening comments on the two major Supreme Court cases involving social media this year, and then we'll go to questions.
Very good. Thanks so much. It's a pleasure to be here. I'm delighted to have been asked and to participate in this. It really is tremendously important work that you're doing, and I'm delighted to be a part of it. This is the social media term of the Supreme Court. The court has had very few cases until now dealing with how the First Amendment interacts with social media or the internet more generally. And finally, the Supreme Court is catching up with technology, or at least making a move in that direction. And so this year we have four cases that deal in one way or another with social media, and I'm going to talk about a couple of them. The first one is a case called Lindke versus Freed, which involves social media and a public official's attempt to block comments that were critical of that public official's behavior in office. Now, as most of you know, I imagine, one of the most important freedoms that we have in the Constitution is the right of the freedom of speech. And yet, most of you, I think, would realize that it would be a different question if the government prohibited you from posting matters on social media or accessing the internet or publishing a book or something like that. That would present a different question than if your parents blocked you from doing the same kinds of things. Even though you still might not be able to exercise a certain amount of freedom of speaking, it matters who it is who's restricting your freedom. When the government restricts your freedom, we might have a constitutional violation because the First Amendment says that Congress, and by extension, any other part of government, shall make no law restricting the freedom of speech. But it doesn't say anything about what private parties, non-governmental actors, can do. And so if it's your parents or your neighbors or your friends or anybody else who's stopping you from exercising your freedom of speech, it might be wrong, it might be a problem at some level, but it's not going to be a constitutional violation because only the government can violate the Constitution. We lawyers call that the state action doctrine. Only where the state, where some form of government acts, can you have a constitutional violation. And that doctrine is really at the heart of this case. Now, Mr. Freed, the case is Lindke versus Freed, Mr. Freed was the city manager of Port Huron, Michigan. And he had a personal Facebook page, and he posted photos of his family. He made posts about what he did. He made posts about his children. And he also made posts about how he behaved in office, events that he was holding. He publicized certain city activities and that sort of thing. And so this was his personal Facebook page. It wasn't owned by the government. It wasn't managed by other kinds of government employees or anything. It was his Facebook page. But on that page, he included both personal items and some governmental items. Well, Mr. Lindke did not like the way that Mr. Freed was exercising his duties as the city manager, and he said so on comments that he attached to Mr. Freed's webpage. He criticized Freed for the way that he was handling the COVID pandemic in particular, and Mr. Freed got sick of those comments and deleted them and then blocked Mr. Lindke from posting any further on Mr. Freed's webpage. Mr. Lindke then sued and said, "You're violating my free speech rights by preventing me from making these comments." He said, basically, that your webpage is a public forum. You've opened it up to members of the public to comment on, and when you restrict the speech of people you disagree with, well, then you are picking and choosing who can speak on your page based on what their viewpoints are of your job in government. And he sued and he said this violates the freedom of speech. But the trick for Mr. Linkey is that he can he can claim that there's a constitutional violation only if Mr. Freed was acting for the government. If he was acting just as a private citizen, and city managers are also private citizens and have First Amendment rights of their own, if he was acting as a private citizen, then he could block Mr. Linkey just like any of us could block someone who makes comments that we don't like on our own personal Facebook pages. The Supreme Court didn't completely decide how this case should come out. It set a standard and then sent the case back to the lower court to apply that correct standard. But here's the standard that the Supreme Court said should apply. Supreme Court says that this should be a First Amendment violation. The First Amendment is implicated. This is the action of the government. Only if two parts. Number one, the person whose Facebook account it is must have the authority to speak for the government. It's not just enough that he's a government employee. He must have the authority to speak for the government, to be the government's spokesperson on this kind of matter. And number two, when he makes this post, he must be intending to exercise that authority. That is, he must be speaking for the government rather than speaking in his own private capacity. So a two-part test, both of them have to be satisfied before we can have any possibility of a First Amendment violation. If either of those is absent, then he's just speaking on his own. Now, another case, I think we're going to get into a different social media case, and I'll discuss that. I can just introduce it only briefly. During the COVID time, there was a lot of disagreement. There was a lot of bad information out about treatments and vaccines and all other kinds of matters related to COVID. The Biden administration communicated with social media companies and told them when the government had found speech on those social media platforms that the government believed to be false. The government didn't want false information spread about COVID or some other things. And so the government said, the Biden administration communicated to these social media platforms, we think you ought to shut down this false speech. We think you should take these posts down because we think that this person is spreading false information. Biden administration was accused in doing that of violating free speech rights. Now, the government couldn't itself order those posts to be taken down just because they're false. The government doesn't have that kind of power. That would be a violation of free speech rights if the government stopped you from saying something just because the government thought what you were saying was false. But does it make a difference that the government here wasn't ordering those posts to be taken down? It was asking Facebook, Twitter, etc., to take down those posts. So does that state action doctrine recur here? When Facebook and Twitter acted on that and did take down those people's posts, was that just the action of those private social media companies, or was it the government? Because the reason that the social media companies did what they did was because of this pressure that the government put on them. Now, that case has not been decided yet. The Supreme Court heard oral argument and will be issuing a decision sometime between now and the end of June. So I think I'll stop there and leave plenty of time for questions. But again, thank you very much for the invitation to be here. It's a delight to be able to talk with you about these important matters.
Well, thank you. That was a great overview. I'm going to go ahead and hand it over to Janine. I know you've got a lot of questions, and thank you so much, Professor Dimino.
Thank you.
So I have an interesting thought on this, Professor, and I'm really glad that you brought up both cases at once. And by the way, I have on my headphones, so can y'all hear me okay?
I can hear you just fine.
Okay, perfect. Okay. I was thinking about this, and I'm so glad that these cases are going to court and they're going to the Supreme Court. In a way, what social media has become today is the tavern, the local tavern, the local town hall where people would go and they would sit and they would talk about things. And someone also likened the television once to the hearth or the fire. People used to sit around the fire and talk, and now people don't sit around a fire and talk anymore, but they sit around the TV. And which the fire was much better than the TV as far as I'm concerned on most occasions. But in the town hall or in the tavern, if people are just getting together, or let's say a family's getting together and they've got some friends, you have every right in the world to say, I don't believe in this vaccination. And the other person can say, well, I do believe in it. And they can say, well, but I've heard this, this, and this. And the other person can say, but I don't think that's true. I've heard this and this and this. And that's a conversation that you're entitled to have. And then you're entitled to have that on social media as well. And the fact that it's shut down and that the government, kind of duplicitously came in, and I'm not making a conservative or a democratic stance here. I'm sure it happens on, whatever. But I mean, to come in and say, we're suggesting that you take you down. Well, if the president and the government's calling and saying that, that's a lot of pressure, whether they're asking or telling. But to stifle that speech that you would be entitled to have at a tavern or at the town hall or in a park or in an open forum, wherever you're entitled to say, I don't want to have that vaccination. I don't believe in it, or whatever it may be. To shut that down on social media. Here is my big equation. Do you know what I think this equates to?
What?
The Alien and Sedition Acts. If you're saying anything that we consider seditious, you're shut down. And I think that that's what this is. You have to say what we think you can say, what we want you to say, and if you don't, then you're shut down and you're in trouble. So I thought that was kind of an interesting. It's a little more extreme, of course, because I know with this edition acts, and I love John Adams, so I hate to ever say anything that and whatever. But that I think then people had to go to jail, and here people don't necessarily have to go to jail or anything of that nature. But I it will be very, very interesting to hear what the Supreme Court says about this second case, especially. And I think in regard to the first case, he either has to have a separate where he closes off his friends and says only certain people are accepted, and it's going to be my personal page, and then I'm going to have a professional page, and to blend the two, that might be something people really need to think about. So what are your thoughts about that, Professor?
As to the last part, I think you're absolutely right, and I think good lawyers will recommend to public officials in the future that they create separate web pages. And if you want to have a personal Facebook page, that's fine. Keep the business stuff out of it. And if you want to have a business page, that's fine, but don't mix the two. The problem is that's not a total solution, because there are some matters that it's hard to classify that come in somewhere in between. For example, if a public official, the mayor of your town, posts that he spent the last weekend attending a festival that was put on by the city. We just came off of Easter weekend, so if the mayor of your town posts a post saying how he attended some kind of egg hunt that was put on by the city or something, is that a personal post because he's just describing what he did, or is it a governmental post because he's describing the governmental event? It can be hard to classify. As to your
but hang on 2 seconds on this. But if I may step in before we move to the next one, because we have dual topics today. I think the bottom line though is what people are allowed to respond, not so much what he posts, but he shut down one of his constituents from speaking.
Yes, that's absolutely right. And if he is speaking for the government in those posts, then he wouldn't be able to discriminate against commenters based on whether he agreed with their position or not.
Yeah. What if the lower court said? Did you touch on that? What the lower courts have already said?
The lower courts in that area, as to that, the first case, Linkey versus Freed, the lower courts applied different standards than the Supreme Court suggested should be applied. The Sixth Circuit, which is the one that covers Michigan, ruled in Freed's favor, um, but didn't focus on that two-part test that the Supreme Court decided. Other courts have also addressed similar issues, but have come up with even different tests that are different from what the Supreme Court decided and what the Sixth Circuit decided. And those tests focused not so much on what the government official was doing, but on how the web page looked. Did the person's web page appear to be an official governmental page? And the Supreme Court says that's not the right focus. You shouldn't, now maybe it's relevant to see how it looks if you post something on your page that says this is purely the personal web page of so-and-so, then that makes a difference. But the Supreme Court clarified in this case that the appearance, although that was focused on by some lower courts, is not the exclusive focus that lower courts should take in the future.
Well, what if we use the Janine test on this? Okay. What if this government official was at a tavern and he was sitting around like in the olden days? That's where they did all their chatting and their talking around the fire in the tavern. And some constituents were there and they were talking with him. And one constituent said, "I think you're the greatest thing ever." And the other constituent said, "Well, I have a few problems with you actually, and I don't think you're doing a very good job." Would you be in, would you, because to me it's the exact same correlation, a tavern, the town square, on the social media. At that point, if he's in the tavern, could he say, your lips have to be sealed and you have to be kicked out of this tavern and never entered again?
Well, you certainly couldn't do that, but what if you're talking about the public official just being another customer in the tavern? But what if he owns the tavern? Does that make any kind of difference?
But government officials don't own their they're there for 2 years because they're elected. So I don't see how that correlates really, right?
Well, that's the whole debate that the Supreme Court was focused on. And what makes the case so fascinating is what's the right analogy to look at here? Because if he's in control of a governmental web page, let's say in fact, the Supreme Court suggested this. If the Port Huron city manager just
No,
had,
but equate it to the tavern. Equate it to the tavern.
well, if you got control of the tavern by virtue of holding the office, and you threw out people for that, then that would be a problem. But if it's your own tavern, if you are the tavern owner and people like your tavern so much that they elect you to be mayor of the town, then you still can throw people out of your tavern because it's your tavern and you don't lose the right to throw people out of your tavern just because you're also holding a public office. And that's what the Supreme Court is trying to figure out in this case. Is this guy had his Facebook page before he became city manager, and they said, well, you don't lose the right to control your own personal Facebook page just because you also take a government job.
But it's so funny. I love having this discussion. The irony is the government comes in the second case, and even though it's his tavern, the government is trying to tell him what to do with his tavern.
Yep.
So in the same thing that you're saying, he owns the tavern, so he can kick out whoever he wants to kick out of his tavern. The government called and said, "Well, it's your tavern, but we want to tell you what to do." So I think it's really kind of cool to keep this in a tavern perspective. And you have to think about his social media page. Is it his tavern, or is he there in the town in a kind of a forum where he's sort of a guest in this forum? It's an interesting way of thinking about it. But I mean, in a way, the government's stepping in the second case and saying, "We're going to tell you what to do in the tavern that you own."
I agree. And it gets even better because in two more cases that the Supreme Court is having this term, involving net choice, the different state governments have tried to regulate how the social media platforms behave. And the social media companies say, no, wait a minute, you can't tell us how to run our tavern. We have a First Amendment right to decide how to run our social media accounts, how to run our platforms. And the governmental attempts to regulate it interfere with First Amendment rights. That's the argument. Again, we don't have an answer from the Supreme Court on that yet, but that's another really important case that goes right to your tavern analogy.
I think I would have really enjoyed law school. Okay, I need to try and having debates with you, Professor. It would have been really fun. I'm going to toss it over, but can you briefly answer the alien sedition comparison? I mean, as far as if you can't say anything that we think is incorrect or you're in trouble, we're gonna, because to me that's what they were saying about the vaccinations. It just seemed, whether you believe in them or you didn't believe in them, to not be able to express pro or con certainly seemed like it was equivalent to those Alien and Sedition Acts.
I think that the Sedition Act is one of the biggest black marks on the country's history, especially from a free speech perspective. And you were absolutely right, even at the very outset of your remarks when you said how if we're sitting around and having a family discussion about things, you have the right to express these kinds of views. In fact, society is better off by having those kinds of discussions, because the way that we figure out what truth is is by letting people with different views offer their opinions, and then people can critique those opinions. So the way that we move forward in our understanding of the world is through a free exchange of ideas. And if the government tries to shut it down, whether through the Sedition Act or through some other kind of modern mechanism, it interferes with that process. Now, the difficulty with this case is that everybody understands that the government can communicate its own views to the social media companies. So if the government says, attention, Mr. Zuckerberg, it has become apparent to us that these posts are speaking misinformation. And we wanted you to know, and we'll leave it to you to decide what to do about it, but we wanted to tell you that in our view, this is false. By itself, that's not a First Amendment violation. The First Amendment violation is if we interpret that as a kind of implicit threat, a sort of mafia style threat that we would like you to take down these posts, and boy, you got an awful nice social media page here. It would be a shame if something happened to it. If we view that as a threat, then it becomes a much more dire case of censorship along the lines of the Sedition Act that you mentioned. But that's what's really tough about that case, is to try to draw the line between merely providing additional information to the social media companies, which everybody says is okay, and threatening the social media companies that you shut down this speech we don't like, or else, and everybody agrees.
But it's like the king coming in and saying,
right.
I just want to let you know that this is, but I'm going to close with this. What's wrong with disinformation? I mean, just because you don't agree with somebody else, A, does that make it disinformation? But B, what's wrong with hearing alternative points of view? If we only have to hear one, as you said, we can't ever seek the truth. So it's kind of scary to me that would be shut down. Okay, I could talk all day, but I have to be a good co-host and pass to the brilliant panel. So I'm going to pass to Tova. Thank you so much.
Thank you, Janine. So this is really, really fascinating discussion. I just wanted to take a step back and look a bit about how the Supreme Court operates in general. So you've mentioned that this is kind of a banner year for the Supreme Court looking at social media related cases. So I was curious about how the Supreme Court decides what cases to take, since this is such like a market increase in specifically social media cases related to previous years. So I guess just wondering why the Supreme Court would choose to take a lot of cases on a specific issue in a given year. And do you think the Supreme Court case selection is kind of swayed by public opinion at all? Since I know that there's kind of like an increasing desire of Americans to see action done on social media policy one way or another. So could you just talk a bit about that process?
Yeah, absolutely. Terrific question. It's, as I think you know, the Supreme Court has a lot of discretion in what cases it can take. We call that certiorari jurisdiction, that the Supreme Court has the power to issue a writ of certiorari and decide what cases it's going to take. That's what that writ means. It issues that writ when it decides to take a case. And there are various factors that the court will look at in deciding what cases to take. But what probably the most important one is when the lower courts have disagreed on the applicable legal standard. So in this case, in the Lindke versus Freed case, we had one of those disagreements. The Sixth Circuit applied one standard. The Ninth and Second Circuits applied different standards. And so the Supreme Court said, well, we can't have these same legal questions coming up in the entire country and then being decided different ways in different parts of the country. We have one First Amendment, the same freedom of speech should apply throughout the nation. We can't have two different standards in different places of the nation, just depending on what circuit you happen to be litigating the case in. And the Supreme Court does this with other cases, not just constitutional law, but statutory interpretation cases too. The Supreme Court really views a core element of its job as unifying the law, establishing a uniformity of interpretation of federal law. And so that's now, does the Supreme Court consider public opinion in doing that? Well, the Supreme Court is, like anybody else, aware of it. And to some extent, the Supreme Court, I think, would even admit that, yes, we do consider that kind of thing, because another factor that the court considers is the importance of an issue. That if an issue is really important, if it's going to come up again and again, then it's all the more important that the Supreme Court establish what the law is and unify that for the country. If it's something that is not all that important, doesn't get people concerned about it, doesn't yield a lot of litigated cases, then it's just not as important for the Supreme Court to spend its time on that case.
Well, thank you. That's really fascinating. And then I was curious if we could return to the discussion we were having earlier about how to determine whether a government official is acting on behalf of the government versus as an individual. I just think that's super interesting. Like, how does one separate the personal from the business? Like, if I'm a politician, like I'm, a councilwoman or something, and I'm out and about with my kid, and someone comes up to me, and kind of like tries to talk to me. I mean, could I walk away?
Yeah.
Or, if they were talking to me about something not related to government, like how does one act in a personal capacity versus a government capacity?
Yeah, I think that's it's such an important question, and the Supreme Court, the justice who wrote the opinion was Justice Amy Coney Barrett. She wrote it for a unanimous court, and she writes in a very conversational, understandable style. In fact, I'm pretty sure that this is the first case in Supreme Court history to use the word snarky in an opinion. And one of the things that she talked about in the opinion was she drew an analogy to exactly what you're talking about. And her example is the barbecue. What happens if a public official just has a barbecue on a weekend and mentions some kind of government policy to a bunch of people who are over at his house? Well, the court said that's clearly, even though it relates to a government policy and even though it's spoken by a government official, he's clearly in that context not speaking for the government. But if he gave the same message at a meeting of the town board, well, then he would be. And so that kind of context makes a difference. The content that is being said also obviously makes a difference. If you post something about, your kid getting her picture taken with Santa Claus, then that's obviously not going to be government policy. But the court said it's very fact-intensive inquiry. You have to look at the posts and look at the page to see whether it is the speech of the government or just the individual who happens to be working for the government.
Interesting. And then kind of a ancillary question I have to that concerns perennial question of hate speech versus like political speech or free speech. So I'm thinking, for instance, one application of however this is ruled is, what if there's a politician, maybe it is a public, a government related page or something. What if somebody is leaving comments that are very personally hateful, using racial slurs, using, like it's like a very ad hominem attack, not really related to a policy. And this government official, even though they, want to respect free speech rights, maybe doesn't want that up on their page when where other people can see it, where children can see it. Um, you know, what how does that like idea factor into the case when it's kind of a blurry line sometimes between political speech and hate speech? But what if it's like just a very clearly an instance of just someone very angry, maybe because of a policy, but just an attack that is not like a discussion on an issue?
Yeah, and some political speech is hate speech and vice versa. That hate speech is not a separate category under the law. The law doesn't recognize hate speech as a category, but people in general refer to that kind of concept as speech that denigrates other people or groups of people, um, and and certainly public forum pages in the social media age, or physical public fora in the real world, um, it, they have an interest in making sure that people are comfortable using those areas. And by toning down speech, by enforcing some what we might generally call civility rules, that you're allowing the page to be used by more people, and the courts will recognize that. The Supreme Court has not been too specific on what the rule is with respect to those yet. Perhaps it will in the near future. But if the government wanted to enforce neutral rules about decorum, then I don't have much doubt about the government being able to do that. Saying, like you say, personal attacks, vulgarities, that kind of thing. The government can have a policy that says, behave yourself according to these rules. Now, not all the rules will be okay. I'll get into that in just a minute, but the government can have some kind of policy like that. What the government cannot do is pick and choose and say, oh, well, you used vulgarity, but I like your message, and so I'm going to let you continue to use the forum, whereas someone else who uses the same kind of vulgarity but has a message I disagree with, I'm going to shut him down. You can't play favorites that way. You can't, what the lawyers will say, engage in viewpoint discrimination. We can't discriminate against people based on the viewpoint of their speech. But we can say, in all likelihood, we can impose at least some limits on the speech that people say if we're going to enforce it neutrally. Now, that doesn't always work, because in some public forums, you're just out on the street, or in the Boston Commons, some public park or something, and you want to have a protest, and your protest includes vulgarity. Well, the government isn't allowed to shut you down to enforce some kind of free speech niceness code in public. That's too broad. Can't say, when we're outside, we're going to behave ourselves in this state, and we're not going to use four-letter words. Well, that violates the First Amendment. But if you did the same kind of thing with respect to a government-run web page, I think that's likely to be viewed different, although we don't have a Supreme Court case saying so explicitly yet.
Well, thank you so much. These are such relevant questions. I mean, we're watching legal history be written as we speak. So thank you for being on and explaining that. And with that, I'll pass on to the next person.
All right, I have the perfect next question to what you just said. Free speech has always been something I really struggle with when we talk about on the show, because it's very hard to quantify in a way, and it's hard to understand, because the way we've now had to build free speech and try to protect it is so different from how it necessarily was enforced or protected early on in the Republic. And so the example you just gave about if you're having a protected political assembly, that the government can't use the protection of saying you can't use vulgarity in order to censor that political expression. It's difficult because in our history, it would have been that would have been used, and we see it actually throughout history. And then it gets very negative when we look at it being used in the South to silence a lot of the assemblies that were in favor of civil rights or something. And there would be not a true attack on it being vulgar, but there would be the accusation that there was some form of vulgarity. So I guess what I'm trying to understand is that it seems like we've had to move to some this idea of an absolute free speech because we couldn't agree on any other way to protect it, even though that's not necessarily how it was written initially. That was like as if initially we figured we could understand what speech that the government would be censoring in order to protect the government from scrutiny versus speech that would be being seen as vulgar. But when you try to then understand the history of free speech laws and the history of how free speech was exercised in the nation, then it becomes very, very hard to have a coherent picture of what is free speech according to the American founding documents. So could you just say something about that kind of a conundrum that many people would have looking back at our history as soon as they realized that there were plenty of vulgarity laws and plenty of what we would call now censorship?
Yeah, I think that the look into history in that way can be fascinating because on the one hand, as you say, the framing generation does tend to be more accepting of a lot of limitations on speech than we are. On the other hand, it's not entirely clear what they meant by free speech. That as evidenced by Miss Turner's example of the Sedition Act. The Sedition Act was passed by Congress, signed into law by the president. There was a substantial group that thought that seditious libel was not within the protection of the freedom of speech. Obviously, other members of the federal government disagreed, and as soon as he took office, President Jefferson pardoned everybody who had been convicted under the Sedition Act because he believed it had been a violation of the First Amendment. So if you look at history, there is some disagreement, but I think you're right overall that certainly the framing generation did have a little a more restrained, restricted view of what free speech was than we do now. What we've done, particularly in the 20th century, and free speech case law at the Supreme Court is really a product of development after World War I. But what the Supreme Court has said is we're going to try to figure out why we have a protection of free speech, what the free speech clause in the First Amendment was designed to protect. And there are two main answers that the court has given. Number one is the search for truth in the marketplace of ideas, that only by exchanging views and testing them against other people's ideas can we figure out what really is truth. If the government just says, we've decided that this is right and we're going to establish an orthodoxy and we're going to make it illegal to disagree with us, then you're not likely to advance and figure out what real truth is because you're not going to be able to question what that orthodoxy is. The other major theory is the self-government rationale, that only if we have the ability to discuss issues and public policies and public officials and candidates, only if we can discuss all of that, can we decide intelligently who to vote for and what kinds of public policies to push forward.
That's so interesting.
Because, yeah, because America is, the sovereignty is with the people and we get to decide, it's all the more important that we be able to get and discuss the information that might go into those decisions.
That's great to hear more of that. So it was a 20th century as the case law developed that was the basis. Great answer. Thank you. Did not know that. So then so kind of tie it into the social media piece. And hearing what you just said today, it seems like we have an easy time defending any type of vulgar speech, and including things like if you go on a little while ago, we started to see a real uptick on the main social media sites of very extreme violent images, images of death, images that the news stations regulate possibly by the FEC, whatever they're regulated by, always blurred out these images where you could see what it was, but they would not show certain things. And we saw these things popping up all over on social media all of a sudden, and different people have different timelines of when, but it's a fairly recent development. But then at the same time as these things are slipping through or they're being protected, political speech is under a far greater scrutiny, and the finger will be tipped on the scales of the reach of individuals uh, from these companies, which are considered platforms, and that's why we call them the tavern. Why we're talking about it that way, which really, really helps us pull it out of the. It really helps us bring it down to real world situation if we think about it as in being in person. So so it's really hard to accept that, okay, so these companies decide certain people get to have a bigger reach and they can just say, oh, that's for our own self interest because we're a private company that wants to make money. But at the same time, here's these other things, and we can't limit their vulgarity or death being shared or these extreme violent things or beheadings. But we can do both of those things at the same time. So we can't limit this because, hey, it's free speech or we're open platform. Hey, but we have this type of a justification, misinformation. It's dangerous to share this, whatever type of a justification to directly limit speech through algorithmic maneuvers.
That what your question there goes to another major debate about social media and free speech involving it's what kind of analogy should we use for the social media companies? Should the social media companies be viewed as kind of the modern equivalent of newspapers, where newspapers can decide what they want to publish, they can decide what they don't want to publish, they can decide what kind of standards they have. So if they want to say, you know, we're not going to publish descriptions of violence, or we are, or we're going, that's up to the newspaper. Can social media do the same thing? Or should social media be viewed as something equivalent to, say, the phone company, where the phone company doesn't say, I'm going to let you place a call to your friend, but if you start saying the wrong kind of thing, then we're going to disconnect the call. The phones company is called a common carrier, that it just provides the service and doesn't get involved in any of the content. Well, social media companies are sort of in the middle of that they, by and large, they don't tell you what kinds of things you post on your Facebook page or what kind of tweets you send out, but they reserve the ability to do that, and on occasion they do say that your content is something we disagree with or we're not going to tolerate, and so we're going to intrude into what you think of as your page. It's really, we're letting you use this page. And if you violate our terms of service, then we're going to shut you down. Well, if some people in Congress are arguing that if those social media companies are going to use that kind of editorial control, then they should be subject to the same kinds of restrictions that newspapers are, in particular, lawsuits for things like libel. And if they allow posts that libel somebody else, then maybe they can be sued just like a newspaper can. Nobody thinks about suing the phone company because everybody understands that the phone company doesn't meddle in private communications. And some of the people in Congress think, well, if the social media companies really like being immune from those kinds of lawsuits, then they should take a totally hands-off approach and not take down people's speech just because they happen to disagree with it.
Just really quick, if we went the first approach of them becoming like a newspaper is probably completely unfeasible. They would cease to exist. In the second approach, in the way that they are, in the second approach, then you'd have the issue of completely no, like it would be the wild wild west of what's posted. Do you think there would need to be a new laws passed that had to do with exactly that spelled out more so what exactly can be posted then on these sites? That the same way that if you have local ordinances that tell you that you can't put up certain signs on your front lawn, or if you go into somebody's outside of somebody's business that you can't say or hold up certain signs.
That's entirely possible. The trick is that those rules themselves um, might be challenged as discriminating against speech on a certain content. So if those rules were don't post COVID misinformation or something, or then don't post any opposition to such and such war, well, then you'd be using the post to discriminate, which if you got the newspaper idea, then newspapers can decide what kind of message they want to promote. But that's not the common carrier framework.
Very interesting. Okay, I bet we have a bunch of audience questions that we need to get to, but thank you.
You.
Yes, we do have a lot of audience questions, but first off, before getting to those, we do want to thank our listeners on Las Vegas KKVV 1060 AM. Our constitutional chats air on Mondays at 6 p.m. Pacific on Las Vegas KKVV 1060 on your radio dial. Thank you to our Las Vegas listeners. So now jumping into the questions, first off, we have Robert Spiegler. He asks, did any state official present facts on social media to counter the false statements talked about earlier in the podcast?
The answer is yes. Plenty of state officials posted speech that was counter to false information. The question of these debates really is that all that the government should do? The usual kind of refrain is that the remedy for speech that is false is speech that is true. If you see speech that's false, well, correct it by putting out the truth and explaining why it's true. And a lot of times the Supreme Court will say that's what the First Amendment requires. The First Amendment says you can't just shut down someone else's speech because you think it's wrong. Explain why it's wrong and say what's true. So that's but a lot of people say, well, that's not good enough because people are still going to be misled by the false information, and it will cause other kinds of problems. But yes, the answer to the question is yes, certainly there were people who engaged in counter speech.
Great, thank you. And then Rebecca Hamilton asks, does government have the right to remove a person's comments? And she says not block that person on a social media page.
The Supreme Court drew a distinction between those two actions. Both of them were involved in Linkey versus Freed. And generally, the government would not have the authority to do that. A person who happens to hold a government office might be able to remove comments from that person's personal social media page. The only difference between removing comments and blocking a person is that if you remove comments from a certain post, then the court or us, we can decide whether that post is government speech. And if the post is not government speech, if the post is purely private, then the individual would have the ability to block comments on that post. But with blocking the person from commenting on any post, that's different because that eliminates the ability of that blocked person from making comments on governmental matters or private matters on that person's Facebook page. So the answer is that the public official can do both of those, but only with respect to personal speech. If it's the government's speech, then the person acting on behalf of the government may not remove comments based on a disagreement with them and may not block the person.
Okay, I think we have time for maybe one more question before kicking it back to everybody else. But Julianne Smith asks, why does the Supreme Court sometimes kick a case back to a lower court for some sort of decision or action rather than just writing their own decision?
The reason for that is that the Supreme Court's function is to decide interpretations of law. What does the law mean? What does the First Amendment require? That kind of thing. The Supreme Court is in a really bad position to make determinations about facts of individual cases. What happened? What was someone intending to happen? Any of those kinds of factual questions that you might think of to be decided because of witnesses, or a jury gets to decide who's telling the truth, any of those kinds of matters, the Supreme Court can't decide those because the Supreme Court doesn't take testimony. The Supreme Court doesn't evaluate credibility. Supreme Court just interprets the law. So when we have one of these cases where the lower courts apply an incorrect interpretation of the law, the Supreme Court will say, oh, your interpretation of the law was incorrect. Let me tell you what the correct interpretation is. And now you apply the facts that you find to that correct interpretation. We'll leave the fact decision and the application of those facts to the courts that are lower, that are closer to the individual situation of each case.
Great. And if Jewel, if you want to join in, or Janine, if you guys want to ask any questions as we round up the rest of the hour, feel free to go ahead.
I have a quick thing I'd like to say, but Jewel, I don't want to step on you.
No, go ahead. I asked a bunch.
Okay. Well, I found it was interesting when you said when something's posted that's false. And what I love about what you said today, Professor, is the marketplace of ideas. I think that's really what we need, and finding the truth through hearing both sides of an opinion. I really respond well to that. I think that's incredibly important. But when you said, like, when something's posted that's false, and of course, if someone says 2 + 2 is 0, well, I guess that would be false. But so many other things that people say to come back in and say, well, that's just false. They said the world was flat forever, and then people came in and said, well, that's it's true, the world is flat, and someone comes in and says, but it's false, it's not flat, and then, like, well, you're a heretic. How dare you say that the world isn't flat? Or but Einstein is correct with his theory relativity, and then you get quantum mechanics and quantum physics that comes in and says, well, actually, maybe that's false and not true. If you can't say that maybe there's another answer and maybe something might be false, how does anything ever grow?
I think that's a very insightful question. The Supreme Court has recognized that, yes, there are such things as truth and falsity, and of course, juries are tasked with determining what the truth is in litigation all the time. But with historical questions, with scientific inquiry, with those kinds of things, we say truth and falsity with a measure of reservation, that we understand that the process of discovering what the truth is a trial and error process. We put out a hypothesis, we test the hypothesis. If it doesn't work, we come out with other ideas that might explain phenomena better. Now, there are some examples of posts besides your arithmetic one, where we do have provably false statements of fact that lead to problems. And libel cases are a great example of that kind of thing, that someone, a speaker or a publisher, can damage someone's reputation by telling a lie about that person. And our libel suits have allowed that defamed person to recover damages for the harm done to that person's reputation because of the lie. So now we don't tend to shut those down. We don't say you're not allowed to speak a libel, but we say if you do print a libel or you do speak a defamation, a slander, that you can have to pay damages because of that. So we do impose something of a penalty for false speech in that context. And there are other examples too. Obviously, commercial fraud is an example. We punish people for misstatements in commercial enterprises. And perjury may be the best example of it all. If you get on the witness stand and you tell something that is false, you can be imprisoned for it. But typically, of course, is the context of your question, you're absolutely right that most of the time when you're making a statement in public, whether it's about science or anything else, we assume that the reaction to that by people who disagree is to explain why they disagree, why the original speaker is wrong. It is generally not within our free speech tradition to shut down speech that we disagree with. Instead, that remedy is more speech. Get out the speech that is true. Don't shut down the speech that you think is false.
Fabulous. Wonderful discussion. Really terrific, Professor. Thank you so, so much. I mean, so I guess what it is the category that you're talking about where you say something's false. And I was thinking from sort of a scientific, philosophical perspective, probably a lot along the lines of the vaccines, you know, when people would say, you have to take it. Well, it's perfect. It's wonderful. Well, maybe it's not. And it just seemed like, then from a scientific, that's always changing and evolving, and to so I guess it would obviously depend on the category. And that's what's so amazing about law. Law is like, well, this is right, but look over here. It's
That's
really a
right.
fascinating mindset. So thank you very, very much. And I think our audience, what a great show.
Thank you
Very
again for
timely.
the opportunity to be here. It really was a pleasure and an honor.
Well, it was ours too. Thank you so much. Thank you, everybody.